I declare the motion passed. Companies Amendment No. 2 Bill 2024. This Council now becomes Committee of the Whole Council to consider the Companies Amendment No. 2 Bill 2024. Members may refer to the appendix to the script for the debate and voting arrangements for the bill. Members have been informed that the committee will conduct a joint debate on the clauses and amendments. I now propose the question to you that the following clauses stand part of the bill. Clauses 1 to 287. The Secretary for Financial Services and the Treasury will move amendments to amend various clauses and add the new heading and new clauses. Members may refer to the appendix to the script for details of the arrangement of the amendments. Members may now proceed to a joint debate on the clauses and amendments. I will first call upon the Secretary for Financial Services and the Treasury to speak, but he is not required to move the amendments at this stage. Then I will call upon members to speak. Upon the conclusion of the joint debate, the committee will first vote on the clauses with no amendments standing part of the bill, then proceed to deal with the amendments according to the arrangement set out in the appendix to the script. Secretary for Financial Services and the Treasury. Chairman, I move amendments to the clauses just read out. The government proposes these amendments in response to the comments made by the Bills Committee, stakeholders, and the legal advisor during the deliberations of the bill. We also need to make other technical and textual changes to the bill. I will deal with these amendments in groups and highlight them group by group. The first group of amendments covers measures to manage the security risks of the redomiciliation regime. The proposed new Section 820C of the Companies Ordinance under the bill empowers the Register of Companies to refuse a redomiciliation request if the registrar believes that the company applying for redomiciliation is likely to be used for a purpose that is unlawful or contrary to public interest. The BC discussed the provisions involved in depth. After considering the BC's comments and the prevailing national security legislation of Hong Kong, we propose an amendment to these provisions to state with greater clarity that the registrar must refuse a redomiciliation request that may be contrary to national security and public interest. This is to ensure strict control over the potential national security risks posed by a company making such an application. The second group of amendments has to do with the eligibility and documents for applications. Having taken into account the views of the BC, stakeholders, and the legal advisor, we propose amendments to the following criteria and documents. 1. Clarifying the requirement for members' consent under Section 4 of the proposed new Schedule 6A and Sections 1 and 2 of the proposed new Schedule 6C by specifying the threshold as a resolution passed by a majority of at least 75% for greater clarity. 2. Clarifying one of the requirements about an applicant's ability to pay their debts under Section 2 of the proposed new Schedule 6C by specifying that the applicant must be able to pay their debts that will fall due within 12 months beginning on the date of the application. This is to reflect the policy intent accurately. 3. Adding a requirement under Section 2 of the proposed new Schedule 6C of the Companies Ordinance that the legal opinion required to accompany the redomiciliation form must be issued by a legal practitioner practicing the law of the applicant's place of incorporation within 35 days before the application date of the redomiciliation. This is to ensure the validity of the legal opinion. And 4. Deleting the duplicate provisions about the registrar demanding further accompanying documents for a redomiciliation form under Section 2 of the proposed new Schedule 6C of the Companies Ordinance, since the proposed new Section 820C subsection 4 already empowers the registrar to ask an applicant for further documents or information when considering a redomiciliation request. The third group of amendments has to do with new offenses about the redomiciliation regime created under the Companies Ordinance and the Banking Ordinance. Such amendments include 1. Setting out the consequences of a redomiciled company of non-compliance with the registration requirements proposed under the new Section 791 subsection 8 under the Companies Ordinance. 2. rendering the new offence of the failure of a redomiciled company to deliver directors' written consent under the proposed new section A20G subsection 2 a compoundable offence, and 3. For the new offences proposed for authorized institutions, AI holding companies, and approved money brokers providing the Hong Kong Monitoring Authority with false documents during redomiciliation under the Banking Ordinance, we will align the levels of fines for these new offences with those for existing offences of the same nature. We also move a number of technical, textual, and consequential amendments. They include aligning the term material date under the proposed new Section 139 subsection 6 and Section 334 subsection 5, and the Chinese term for place of incorporation or 成立為法團所在地方 under the Companies Non-Hong Kong Companies Regulation. This is to ensure consistency. We also amend references to other provisions under the proposed new Section 381 subsection 1A of the Securities and Futures Ordinance and the amended Section 1 subsection 1 of Schedule 2 to the Anti-Money Laundering and Counter-Terrorist Financing Ordinance. We will also simplify the drafting of the existing definition of redomiciled OFC under the SFO. The Securities and Futures Approved Securities Registers rules took effect upon gazettal during the deliberations of the bill. In light of this, we will add a new provision to the bill to amend the definition of basic information so that it covers the past and latest places of domicile of a corporation. We will also rectify the discrepancy between the existing Chinese and English text of Section 564 of the Companies Ordinance. When preparing these amendments, we weighed the comments of the Bills Committee, stakeholders, and legal advisor with prudence. The BC and its legal advisor have no objection to any of these amendments. Chairman, I so submit. I urge members to support these amendments. Does any member wish to speak? If not, we now first vote on the clauses with no amendment standing part of the bill. With those in favor, please raise their hands. Those against, please raise their hands. I think the question is agreed by a majority of the members present. I declare the motion passed. This committee now deals with the clauses with amendments. Secretary for Financial Services and the Treasury, you may move your amendments. Chairman, I move the amendment set out in the appendix to the script. I propose the question to you that the Secretary's amendments be passed. With those in favor, please raise their hands. Those against, please raise their hands. I think the question is agreed by a majority of the members present. I declare the amendment passed. Clauses 15, 66, 68, 76, 77, 83 to 87, 119, 157, 199, 242, 246, and 271 as amended. And I'll put the question to you that the clauses as amended just read out by the clerk stand part of the bill. With those in favor, please raise their hands. Those against, please raise their hands. I think the question is agreed by a majority of the members present. I declare the motion passed. We now deal with the new heading and the new clauses. New clause 45A, Section 564 amended, Special Resolution. Heading of the new division before the new clause 260A, Division 31A. Securities and Futures Approved Securities Registrars Rules. Cap 571, Sublec AT. New clause 260A, Schedule amended, Notification of change. Secretary for Financial Services and the Treasury, you may move the second reading of the new heading and the new clauses. Chairman, I move the second reading of the new heading and the new clauses just read out by the clerk. I propose the question to you that the new heading and the new clauses read out by the clerk be read the second time. With those in favor, please raise their hands. Those against, please raise their hands. I think the question is agreed by a majority of the members present. I declare the motion passed.
New clause 45A, heading of the new division before new clause 260A and new clause 260A. Secretary for Financial Services and the Treasury. Chairman, I move the new heading and the new clauses just read out by the clerk. I propose the question to you that the new heading and the new clauses be added to the bill. Will those in favor please raise their hands? Those against, please raise their hands. I think the question is agreed by a majority of the members present. I declare the motion passed. All the proceedings on the company's Amendment No. 2 Bill 2024 have been concluded in Committee of the Whole Council. Council now resumes. Secretary for Financial Services and the Treasury. President, I now report to the Council that the company's Amendment No. 2 Bill 2024 has been passed by Committee of the Whole Council with amendments. I move the motion that this Council adopts this report, and I propose a question to you that the Secretary's motion be passed. In accordance with the rules of procedure, this motion shall be voted on without amendment or debate. And I'll put the question to you as stated. Will those in favor please raise their hands? Those against, please raise their hands. I think the question is agreed by a majority of the members present. I declare the motion passed. Third reading. Company's Amendment No. 2 Bill 2024.